The heat on this channel, so make sure that you subscribe, hit the notification bell, because YouTube doesn't always send out notifications when I drop that heat. Nevertheless, let's go ahead and dive into this video. Judge Kirkham, he's telling everybody what happens when you lie to him in his courtroom. This video is multiple hearings in one, so sit back, get ready, enjoy the show. Without further ado, let's dive in. Fair use, fair use.
Why did you answer no when you knew you were pregnant? You testified falsely to the court.
Yes, sir, I did.
The court could, in this matter as well, hold you in contempt and incarcerate you until such time as the children do go.
Also, child support had been suspended because Mr. Van Zandt said he was applying for disability. We've received no information about that, but as I indicated in the motion,
Chelsea Joswiak versus Ryan Joswiak.
Court will note the appearance of Ms. Reed on behalf of plaintiff, Ms. Henderson on behalf of defendant. This matter is before the court on the defendant's motion to hold plaintiff in contempt and for immediate resumption of parenting time and other relief. Ms. Henderson, obviously we have a substantial docket today. I don't need a rehashing of everything. We do have an answer filed in this matter, which denies the allegations. Therefore, the court's going to have an evidentiary hearing. Is there anything else that you have that we can address today?
No, Your Honor. Essentially, what we're asking is that the consent order that the parties entered into prior to this hearing continue, meaning the parties continue counseling with Meredith Katz and follow all of her recommendations. We would ask that the issue be scheduled for an evidentiary hearing to consider the issues brought up in our motion. Ms. Katz expressed significant concerns regarding coaching of children by the mother. So that is the issue we would like to be brought up at the evidentiary hearing. I would also ask the court to remind the parties that the order has not been changed, so it should be followed as it relates to the parenting time. Thank you.
Okay, thank you. Ms. Reed, anything else other than your answer?
Just that the children are continuing to refuse to go over to dad's home. My client is not denying parenting time. It's that these children are refusing to go, and they're at an age where she cannot physically force them to go. The counseling with Ms. Katz has just recently started. She's had maybe 3 appointments with them. Joint sessions have not started yet, and they're still starting to identify what the issues are of why the children are refusing to go over to dad. So I believe a show cause is kind of premature, so we're asking for it to be denied.
Okay. Well, I do believe that there's a sufficient basis to proceed. The court will schedule an evidentiary hearing, but I want to get some input from the counselor, so we'll schedule the evidentiary hearing after we get a report from the counselor. The counseling in this matter will resume, and it will be in person. I know that there was some issue about, well, doing it Zoom. I wanted in person, so we can put that in the order. Court would order further that the defendant's phone number would be added to the children's phones in this case. The court will reserve on the balance of the other relief, but I would state, if it's determined, Ms. Joswiak, that you are not attempting to facilitate the children going to the defendant, the court will order makeup for all of the parenting time missed. And I just had that happen in a case in which we found out that the mother was not facilitating that. So dad was given about 6 months straight of parenting time. So just want to let you know that the court could, in this matter as well, hold you in contempt and incarcerate you until such time as the children do go. So I'm mentioning that, but that's how we'll proceed. Now, Ms. Henderson, I'll ask that you would prepare an order submitted under 7 days.
Sure, Your Honor. As for report of the counselor, Meredith Katz prefers to testify in person or by Zoom at the hearing. Would that be acceptable to Your Honor?
Yeah, she doesn't have to appear at the hearing at that. She can appear by Zoom.
Yeah, she usually likes to testify at the hearing rather than prepare a report. She does give updates to the counsel via email.
Okay, I don't know. I don't understand what you're asking for then.
Your ruling stated that the evidentiary hearing shall be after Ms. Katz submits a report.
Yes.
So I'm following up on that because usually she testifies at the hearing rather than submitting a formal report to the court.
Well, have her submit a report, and then we'll be able to see what, and then we can, that way it can tell us, kind of give us some ideas to parameters of the hearing.
Okay, thank you, Your Honor.
Okay,
And
thank
would the
you.
hearing be with you or with the referee?
No, it'll be with me.
Okay, thank you
Okay,
very much.
thank you.
Appreciate it. Have a good day.
Bye.
Thank you.
Curiosity Stream's most watched original series has all new.
Brenda Van Zant versus Lance Van Zant.
Court will note the appearance of Ms. McNiff on behalf of plaintiff. This matter is before the court on the plaintiff's motion to modify custody, parenting time, and support. Ms. McNiff.
Your Honor, I know the court's busy today. We're asking to modify the sole legal to modify legal custody to sole legal with my client. Mr. Van Zant simply hasn't complied with the court's previous orders. The children don't have an appropriate place to live, let alone stay when they're at the dad's house. They don't have bedrooms, they don't have clothing, they don't have personal hygiene items. He's living either in a camper at his friend's house or in the friend's house. Also, child support had been suspended because Mr. Van Zant said he was applying for disability. We've received no information about that, but as I indicated in the motion, Mr. Van Zant has the ability to walk from Marshall to Battle Creek, which calls into question his ability, whether or not he's actually disabled. So we're asking the court to unsuspend child support and also to allow me to calculate child support based on 0 overnights, because the children have had maybe 1 overnight with dad in the camper when the weather was appropriate. We would also ask the dad be required to arrange any parenting time with mom and not go through the minor children.
Okay, thank you. Mr. Van Zant, what's your response?
Yes, there's a few of those I would like to address. Yeah, I don't have the clothing and stuff, but the hygiene products are there. I have walked to her house a couple times, but not without consequence. My ankles bleed every time I do it, and I'm down for days afterwards, but I will do it to spend time with my kids when I'm able to. My disability hearing is still in process. I'm waiting for the paperwork for my video hearing for it. That paperwork was sent in. I'm waiting to hear back. I got your information or your letter for medical affidavit, which I got to my doctor. I'm just waiting to get it back either today or tomorrow. Let's see what else. And the mailing address that they put on there is wrong because my address has been changed from her house for a couple years now, since I lived on 15 Mile Road. What else is on here that I would like to address? But yes, basically they are right though, because I am unable to work at the moment, but I have walked to their house a couple different times throughout the year to actually be able to see my kids, because she won't bring them over to me when she's able to. Other than that, I guess that's about right, I think.
Okay. Well, the court does find in reviewing the pleadings that there has been threshold of proper cause or change in circumstances pursuant to Budvarka versus Grassmeyer for a hearing in this matter. The court will refer the matter to the referee for a hearing on the petition. The court will, in the interim, because we're not going to wait indefinitely for a determination on your disability, we can always go back and modify support if it turns out I'm going to vacate the suspension of child support at this time, effective today's date. I'll ask Mr. Van Zant, you can notify Ms. McNiff after this hearing, call her office and give her your new address so that she makes sure that all the pleadings go to your correct address.
She has my correct address because their letter was mailed to where I'm staying.
Well, you were just stating they didn't have your address. So
I was meaning in the paperwork. I was meaning on the paperwork, it says I've been using her address as a mailing address, and my address has been changed before this hearing, way before.
Well, that's not unusual. People move and the address on the pleadings is different, but she apparently sent it to the correct address. So that will be the order, Ms. McNiff. We can refer the matter to the referee in this particular matter, so that we'll take care of that.
Thank you, Judge. Do I need to do an order about
Yeah, you'll need
suspension?
to do an order about vacating the suspension.
I will. Thank you, Your Honor.
Okay, thank you. Free to go. Have a good day.
You too.
Court will note that this matter is before the court on the motion to exclude child filed on February 13, 2024 by the defendant in this matter, represented by Ms. Jansen Miller.
And presently you are still married to Logan Morris, is that correct?
Correct.
And he's the defendant on this action.
Correct.
And during the course of your marriage, you became pregnant, is that correct?
Yep.
And the pregnancy that you recently had a baby, is that correct?
Yes.
Okay. And that pregnancy, you had a DNA test for, correct?
Yes.
And the DNA results indicated that Logan Morris is not the father, is that correct?
Yes.
Okay. And you believe that to be true?
Yes.
Okay. As a matter of fact, you're in a relationship with a gentleman that is named as the father on the DNA, right?
Yes.
Okay. Are you asking in the course of your divorce that this baby would be excluded from your divorce proceedings with Logan Morris and that that child would not be a product of your marriage?
Correct.
Okay. I have no further questions for this witness.
Okay. Ms. Morris, I have one, and in preparing for the hearing today, I went back. I did note that we had a hearing in this matter. I think it was back on January 8th, wasn't it? 10th? Yeah, that's right. We had a hearing on January 10th in which proofs were put on the record in this matter. And at that time, the court asked you if you were pregnant. And
Yes.
your answer was no. Why did you answer no when you knew you were pregnant?
Because I was under the impression that it would be under Logan's child, which I knew it wasn't. After I left the hearing, I called my mom and asked her if I should have said yes. Then I did call and talk to Christy and told her, I said, I think I answered incorrectly.
Well, I guess I'd say, as I do note that Ms. Jansen Miller did attach some attachments to the motion. And on January 8, 2024, you did a posting that said ultrasound, happy third trimester, 2 days before you testified falsely to the court.
Yes, sir, I did.
Well, I want you to know I'm not going to take action at this point, but the court could hold you in contempt and could put you in jail for contempt of court. You understand that?
Yes, sir, I do.
Okay.
I'm sorry for that.
Well, I'm just mentioning it for future reference. If, again, it probably would never happen where you came into court again, but again, if you were in my court again and that came up on any issue and we found out that you were testifying falsely, you would go to jail. So, and you could go to jail up to 93 days. So we don't take these things lightly when somebody lies to the court. Okay. Ms. Jansen Miller, any additional witnesses?
I just real briefly, my client.
Okay.
And you heard all the questions that I just asked Courtney, is that correct?
Yes.
Okay. And you do not believe that you are the father of this child?
Nope.
And you would, like as part of your judgment of divorce with Courtney, to have the child be excluded as a child of yours of this course of marriage, is that correct?
Yes.
Okay. And you understand that that's final and you would not then be able to go back and claim that child or anything to that effect, correct?
Yep.
Okay. I have no further questions, Your Honor.
Sir, do you know when the child was born in this matter?
He was born March 17th.
Okay. Sir, in this matter, knowing that the child was born in March, on March 17th, that would put the time of conception sometime around maybe June, somewhere in that area. At the time that the child was conceived, were you engaged in any sexual relations with the plaintiff?
No.
Okay, ma'am, I'm asking him questions.
Sorry.
Okay, that's fine. Ms. Morris, do you have any questions of the defendant?
I do not.
Okay. Ms. Jansen Miller, anything else?
No, Your Honor.
Would you like to offer the DNA test results?
Yes, I would, Your Honor. I believe they've already been submitted to the court.
Well, but they're not offered and doing.
No, yes, I just didn't send anything separate today. I would like to
Okay.
offer those as our exhibit as proof for the determination.
Okay. Ms. Morris, do you have any opposition or objection to the court admitting the DNA test results?
No, Your Honor, I don't.
Okay. The court will admit the DNA test result in this matter, there being no objection. Anything else, Ms. Jansen Miller?
Nothing today, Your Honor.
Okay. Ms. Morris, do you have anything else?
No, I don't.
Okay. Ms. Jansen Miller, do you wish to make any closing argument?
No, Your Honor.
Okay. Ms. Morris, do you wish to?
No, I don't.
Okay. Just a moment. I'm trying to get to the exhibit. The court has heard the testimony in this matter for both the plaintiff and the defendant. They both have confirmed through their testimony that the defendant in this matter is not biological father of the child in this matter. Child being Bodie Messer. The court has been provided with a DNA test report dated 4/10/2024 of the alleged father, Michael Messer, and the minor child. And the results show a probability of paternity of 99.999999999% in this matter. And testimony of the plaintiff is that they did not engage in sexual relations with the plaintiff at the time of conception of the child. That is consistent with the other testimony as well as this report. And as a result, the court will find that this child, Bodie L. Messer, is not issue of this marriage, is not the biological child of the defendant, and the court would exclude him as the biological father. Ms. Jansen Miller, do you wish to send in a separate order on this? Did you send in a separate order that's in the file? I don't know.
I don't think we sent an order yet. We just had sent the DNA results.
Okay.
We do not have one, Judge.
Okay, if you would send in a order, I'll let you sign it under, or send it in under 7-day rule and exclude the defendant. And further, if you would, the court would terminate that support obligation as of March 17, 2024.
Yes, Your Honor.
Okay. Anything else, Ms. Jansen Miller?
Not at this time. Thank you.
Ms. Morris, anything else?
No.
Okay. Thank you all for attending. You're free to go. Have a good day.
Thank you.
you.
You too.
I don't have.
All right, as you can see, Dad was already ordered to pay for a child that was not his. Mom knew it wasn't his child. She was able to lie in court, and the judge only threatened her. She knew that it wasn't his child. Then she called her mother. Now, if that was my mother-in-law, I probably would have a little tossy-turvy relationship with her as well. But I don't want to state too much of my opinions, but I know for a fact that Dad, even when the case started, he looked out in the window. He was like, man, I want to get out of this. But nonetheless, this is Antonio with Team Tiggio. Please like, comment, subscribe, as we will be coming back with another video very, very soon. And once again, we'll be seeing the next video.